Awesome. Thank you everyone for coming to today's training, Practice and Procedure in Probate. This is our Philadelphia VIP probate training. We've been putting this on for many years, and we are excited to continue to do this virtually. And I hope that the next time we do this, we can do it in person. To get started, I am Mike Jones. I am a senior staff attorney here at Philadelphia VIP. I've been here for 4 years. I've been doing homeownership cases for 3.5 years. So I won't say I am at all a master of this, but I have seen a number of cases before. And so I am happy to guide you through them as you volunteer. Additionally, we are super excited to introduce our special guest, Diane Zilka, who is the 2021 MVP of VIP. She joined Philadelphia VIP volunteering, I don't know how many years ago, like 3 years, 4, 5 years ago. What was it, Diane?
Probably 2018.
2018, okay. And since then, Diane has grown her expertise. She has done mortgage foreclosure cases. She has done guardianship cases. She does estate planning cases. She is truly astounding in that at the beginning of the pandemic, Diane said she wanted to learn probate, and she has taken 8+ probate cases in this period of time, and she is churning them out and getting our clients amazing, successful outcomes, which means title to their home, which means paying off inheritance taxes, which means having them build financial intergenerational wealth. So thank you, Diane. She'll be here to really make sure that you hear that the things that I'm going to say are probably going to be confusing because that's what I do. But Diane is going to ground everything and give you a good idea of what real life is like. And so I'm going to start with our agenda. We've done the introductions. We'll go into a brief history of Philadelphia VIP and pro bono landscape. We're going to talk about the current probate process, how to take a case, and then resources and upcoming events. As mentioned, we're going to cover a lot, but remember, you don't need to know all of this. This is not going to be an exam, although this feels like a class at law school. It is not meant to be that. We are going to show you the linear fashion of these probate cases. This is a to-do list. Training materials that I've sent to you will be really, really helpful to help flush everything out. We have resources, we have training materials, we have staff, we have mentors, we have a lot of ways to help support you through your volunteering. This is not as complex nor as difficult as I will make it feel. Each step is slow and deliberate. The wonderful thing about probate is not only that you're helping someone get title to their home, but nothing happens at full speed. We are dealing with the tortoise, not the hare. So the next slide, just some Philadelphia VIP history. We were founded in 1981. It's our 40th anniversary this year. On May 7th, we will have our gala at the National Constitution Center. I would love it if everyone came. There'll be an auction. There'll be plenty of beer and wine and liquor, and it's just going to be amazing. We were founded in 81 in response to Reagan's federal funding cuts to legal services. In response, partners at a bunch of law firms said, we need to do something to pick up the slack where legal services is unable to. And so they partnered with the Bar Association and decided to do what we do now, which is become the pro bono arm of Philadelphia. We do pro bono all the time, which means that our mission is to leverage the powerful resources of the community and to provide quality volunteer legal services and ensure that access to justice for low-income Philadelphians. Our community in Philadelphia, we are the poorest big city in the United States. More than a quarter of our residents and over a third of our children live in poverty. The median household income has been the lowest growth of all other major cities. So what that means is that we have a number of legal services organizations. We have community legal services. Shout out to Kate Dugan, who's in here right now. We have Philadelphia Legal Assistance. We have Senior Law Center. We have the Homeless Advocacy Project. We have Christian legal services clinics. We have a lot of them, but the demand for affordable legal services far outstrips the supply. So we have a significant civil justice gap, which is why volunteer attorneys are so essential. And we'll get into the numbers in a little bit, but there are too many people who need help, and volunteer attorneys are the way to fix that. Last year, we had over 3,500 Philadelphians who had benefited from Philadelphia legal assistance, over 1,500 engaged volunteers. And I think this number is probably low, but there are over 10,000 attorneys in Philadelphia. So imagine the limitless possibilities. A view of our clients. Our household clients are at or below 200% of the federal poverty level, which means $24,000 a year for a one-person household or $48,000 a year for a four-person household. They're a diverse, multilingual population. They're referred to us through our sister agencies, in particularly Community Legal Services and Philadelphia Legal Assistance. And we are the agency of last resort. That means that if a client is unable to get access to a probate volunteer attorney, to a guardianship attorney, to a divorce attorney, they may not be able to get an attorney. So it's why it is so important and why I am probably always urging people to volunteer. This is just an organizational chart for you to get an idea of what our place looks like. All the blue is our legal team, which means that we have a lot of people who are here to support you. So please just know that our goal, I mean, the amount of time that we spend on moving cases, it's what I do all the time. So, and all of these people in blue do that. So it's really, know that you have a safety net, someone here who supports you and to answer your questions. Tangled title in Philadelphia. As many of you may know, Pew released a report in the summer of August 2021, and they found that at least 10,400 properties, or 2% of the city's residential properties, are affected by tangled title. Collectively, these properties are worth over $1.1 billion, and they are inaccessible wealth. That means that people are unable to sell them. They're unable to encumber them further. They're unable to transfer it properly to their children. The most impacted people are our Black neighbors who are low income. The highest incidence of tangled title up here in the north, the upper north, west, and the southwest of Philadelphia. That accounts to 50% of all tangled titles. The average cost to resolve tangled title is $9,200 according to Pew, and that includes attorney's fees. So imagine that you are helping someone who is low income. Imagine that you are unable to afford the probate process, and there's $9,200 that you have to spend to resolve this. It is so important that we have volunteer attorneys who are able to do this for free, and we have grant programs that are able to help pay off a lot of these, if not all, of the fees that would be incurred otherwise.
Hey, Mike, it's Diane. And if I might interrupt, if you could just in a nutshell, what is the word tangled title? What do those words mean relative to this training or probate? What does tangled title mean? Absolutely.
So what tangled title means is that you are the equitable owner of a property. You have some legal interest in the property, but for some reason you are not on the deed. So the most common type is exactly what we're here for, which is probate. And it means that a loved one passed, they may or may not have had a will, but your client is living in the property and they need to get access to some benefit as a homeowner. And not having title is an obstacle to getting that benefit. And so we will say that tangled title is mostly people who are affected by probate, who are facing the probate process. It's a large obstacle. It's costly, as we just discussed. There are other kinds of tangled title Adverse possession is a real thing. We have other quiet titles like lease purchase agreements. We can assist with fraudulent conveyances, fraudulent deeds, and we do help with mortgage satisfactions as well, forms any kind of cloud to title. But we're here today for the most common, which is heirs properties, is what it's called across the United States. Probate is the process that helps to resolve it, but we here call it tangled title. This is a map of the concentration of those properties and zip codes specifically that are neighborhoods actually affected by tangled title. So you can see the dark blue areas are where the people are most affected. And furthermore, the median household income in these dark blue areas are some of the lowest in the city as well. There is a direct correlation to the median household income and the amount of tangled titles. This is a wonderful little GIF that Diane Zilka had sent over, and this is from the Economy League, but this shows the concentration of poverty as time progresses from 1970 to 2010. And you can kind of see the red is showing where residents in poverty are most highly concentrated. And I will just briefly go back to this, and you will notice that it's very similar to the dark blues here. A little bit more context. Philadelphia has long been have a high rate of home ownership compared to other cities in the Northeast and Midwest. In 2019, 52% of properties were owner occupied. The median household income for the highest impacted areas, as I said, is $28,000. The average cost of probate is $9,200, and VIP volunteers bring access to the legal needs and grants for our homeowners. So what we're going to do right now is discuss what happens when you receive a case. So you are going to have a case summary, and you're going to see what's happening on the property. Then you're going to receive the case file from Philadelphia VIP and look it over, and then move forward with the probate process. So to get started, let's go over case summary in the family tree. Sarah grew up in her family's home. Her grandparents are Harold and Grace. They bought the home in 1984 and are now deceased. Harold died in 2000. Sarah moved into the property with her two children after his death to take care of Grace. Grace began receiving medical assistance in 2002, and she died in 2003. Sarah's grandparents had 3 children: Rose, Sarah's mother, Jack, and Rita. Rose died in 1995, and she was survived by her husband, Max, and her 2 children, Sarah, who is our client, and Anthony, all of whom are alive. Uncle Jack and Aunt Rita are still living as well. Jack moved to California in the early 90s, and no one's seen him since Grace's funeral. Rita lives in Philadelphia with her family. She and Rose are close. Sarah lost her job and has difficulty paying the annual real estate taxes. The tax delinquency is $3,000. She was accepted into an income-based payment plan for delinquent taxes, but needs to try and get her name into the deed to remain in the payment plan. Her father and brother are both willing to give any interest they may have to the property to Sarah. Aunt Rita is also willing to give Sarah her interest in the property. Uncle Jack has not been responsive to Aunt Rita or Sarah when they have reached out. Sarah is willing to share title with Jack if necessary. Sarah needs assistance probating her grandmother's estate, including filing an undue hardship waiver for the Department of Human Services and executing a deed transferring title to Sarah and filing an inheritance tax return. That's a lot of information, and it can be really quickly summed up in a family tree, which is something that we at VIP make a lot of. So you'll see Harold and Grace were married. Harold died in 2000. Grace died in 2003. She was survived by Jack and Rita, Rose predeceased Grace, and Rose was married to Max and had Sarah and Anthony. All 3 of them are alive. and we will get to what happens to the interest in the property in a moment. But when you've accepted Sarah's case through VIP, you will receive in the case file this deed, which is important in learning what the property is, and it'll be very helpful in writing the subsequent deed. You'll also be receiving, this is the property description. You'll also be receiving the Office of Property Assessment, OPA page, which includes the value of the property, which is helpful in distinguishing the cost of probate, and it will help in determining the transfer tax value. And we'll get into that. And then also you'll get the Department of Revenue's real estate tax information. We just want to keep you updated on what the property taxes look like. If someone is in a payment plan, we are made aware of this in advance. Additionally, you will also receive a title report for the property and for those owners who own the property. What is a title report? It is an analysis of the ownership of the property. It'll say who currently owns the property and how they received it. Maybe if there is some issue with the property, it might say whether or not there was something that was improperly recorded. Title companies are able to make note of wild deeds. It'll also list liens and judgments of record, both in personam and in rem. So against the owner of the property. So it could be against Rose or Harold, or it could be against, we also will include in our search our client. So we could find a judgment against Sarah. You would review this. We are happy to help review title reports with you. I look at them all the time. And then you would review this with the client and make sure that any encumbrance or judgment that exists is either manageable or maybe is something that shouldn't have to be worried about. And those are conversations we can kind of go into as they come up. But excuse me, you'll be reviewing. Yeah, please.
I have a question. Mortgages, or they're also on the title report, right?
Yes. Yes.
So sometimes someone is inheriting a house, whether by will or intestate, who's the preceding owner, a relative from whom they're inheriting, has a mortgage on the property. Most times the clients know that, but it is one of the encumbrances. It may not be a lien, it may not be a judgment, but it's definitely an encumbrance that has to just be managed and discussed with the client. So that's the review part.
And a mortgage is, as Diane said, often known if there's an active mortgage. And when we review the title report, or when you review the case file, we may make note of the fact that there is an open mortgage from 1980, and it was for $3,000, and we will make an assessment that says it is likely not a concern. And that means that when you are assisting this client and when you go over the title report, you're going to go over, you're going to have a conversation with them about at-risk distribution. And what this means is you'll review the title report and you'll discuss the obligations and duties of a personal representative who is the administrator of an estate. And you will make a decision about whether or not to proceed with probate because of what risks they may take on. We have a lot of materials to discuss on this. I'm always happy to discuss it, but it's a balance test between the assets and the debts and whether or not advertising is something that would be necessary. I don't think it's going to be productive to go into the weeds on this, but I do want you to know that we often have done this balance test in advance. We are happy to discuss it with you. And we have letters and forms that are very helpful to guide you through that conversation.
Yes, so this is, it's Diane, if I could just say from my perspective, what Mike said is absolutely true. All of the cases that I've taken have been vetted by VIP. Conversations may have already been had with the clients before the case even comes to me. The point of having clients who are very poor is that they can't really proceed with the most cross the T's, dot the I processes required for probate. That would be formal, and that would require advertising. It is prohibitively expensive. So what we're doing with the client is weighing out for them, and it almost, I can't imagine it doesn't weigh in favor of going forward with probate in an informal way, meaning that let's probate this estate knowing that the decedent may have had a credit card debt that they didn't pay, or there may be some other judgments or liens, or including water or gas and such like that, and a mortgage. The question for the client is, can this be managed? Can we proceed with probate? Can we create an estate? And can we distribute assets knowing there may be creditors out there? And 99% of the time for me, it's been worth the risk that the creditors might crawl out of the woodwork because you didn't advertise, and might show up and try to claim, some part of the property that the client is inheriting. Those are the risks. You weighing what's existing against the property, the estate, versus the cost of probating to ameliorate those obligations and other things like that. So I hope that's helpful.
Yeah, and it's absolutely illuminating. And at the end of the day, any creditors that come out and say, hey, we have a claim, one of the things that Philadelphia VIP does is we assist clients with collections cases. So we advise the client, and we ask you to advise the client that in the event that a creditor shows up, tell them to come to Philadelphia VIP. We are happy to find a volunteer attorney who can assist. Often there are great results that can occur where the debts get cleared. So it is not something that people should feel that they should walk away from getting title to their home because they're concerned about something down the line. It's very much a relatively, although at risk is used in the actual description, it is, when you balance it and when you've gone over it, you notice that the risks aren't always as risky as it seems. And so then we would, with all of that information, we would then go and we would try and gather the information, or rather gather the necessary documents to proceed with probate. And at VIP, we've also begun to do this already. But if you recall Sarah's story, under Pennsylvania intestacy law, this is how the interests have all passed. Grace and Harold were married, and they owned the properties as tenants by the entirety, which is as a married couple. When Harold died, Grace became the sole owner by operation of law. Rose predeceased Grace, and that will come in a little bit. When Grace died, the interest, her ownership interest, passed through Pennsylvania intestacy law to Jack and Rita, who are still alive, her two children. They each have 1/3 interest in the estate. Rose, as I said, predeceased Grace and died married to Max and had 2 kids together, Anthony and Sarah. Max does not receive an intestate share of Grace's property because she predeceased Grace. What happens if you predecease is that it means that her shares go straight to her issue. So Anthony and Rose each split the 1/3 interest that they would receive, that Rose would receive, and they each have 1/6.
Mm-hmm.
Diane, I think you're on mute.
I think that would be Anthony and Sarah each.
Oh, Anthony and Sarah. Thank you. Thank you. So in this family tree, the people in play are Jack, Rita, Anthony, and Sarah. Max, although married, does not actually have any interest in the property. And we'll go forward and discuss what we would need from those people. Additional documents you may need is a will, if there is one, death certificates. The Department of Vital Records is open. You may submit applications for death or birth certificates online through mail or by the phone. Things you may need are marriage certificates and birth certificates when you're opening an estate. If, for example, Grace's last name is Grace Smith and Sarah's last name, your client, is Sarah Jones, sometimes the register will say, well, why does Sarah Jones have to open Grace Smith's estate? How does she have a right? And you'd have to show, hey, marriage certificate, she was maybe Grace Jones or Grace Smith, excuse me, Sarah Smith before. And you just want to connect the dots about how someone has this right to serve as the administrator. But people also don't often come to VIP. They don't wake up one day and say, hey, I want to get title to the property. It's something like what Sarah is going through, that they come to get their name on the deed. And reasons may include delinquent real estate taxes or water and sewer delinquency. The lack of ownership has been a barrier for getting payment plans, but now it's become a little bit easier given that the city understands the epidemic of tangled title. By getting access to a legal services attorney through either CLS, PLA, or VIP, we can help stabilize what could be a foreclosure issue. Here's some things to just know about what's going on with real estate taxes, water department, and gas and electric. I call it in the weirds while we're in the pandemic, but for the most part, things are back to normal. But the water department has extended their shutoff protection through April 1st. I'm happy to share this information with you later, because often clients will come and say, hey, I also have this issue. And you may say, I don't know what to do about it. Reach out to me and I will be happy to direct you or direct the client to getting the answers. We have all of the materials already primed. More information on real estate taxes. Just know that there's a payment plan that exists for clients that can make it so that they will have income-based payments for delinquent real estate taxes, and it could be as low as $0 a month. I'm sure Kate Dugan could sing everything about this and provide all the information about this. So I will say, if you have questions on owner-occupied payments agreements or real estate taxes, feel free to reach out to me, because if the question's too much in the weeds, I will reach out to Kate Dugan. Additionally, someone may notice that when the decedent has died, like in Sarah's case, they may have been receiving medical assistance through the Department of Human Services. And therefore, the estate has a claim against it for an amount of money because they were receiving at-home care or nursing home care, the decedent. And the state says, hey, this decedent was receiving this care and they owe money and it's going to be against the estate. And what they want to do is put a claim against the house, and they'll try and collect it. Well, they'd like to collect it. But excuse me, truthfully, what happens is there's a procedure, because our clients are suffering a hardship based on their income and because they may have no alternative housing, that we can assist them in getting that claim, that estate recovery claim, cleared. There is plenty to go into this, but it's a very step-by-step procedural process. And I have plenty of information, and we've created a guide to help you. But ultimately, the important thing is, when you're probating an estate, you would have to notice DHS that you've opened the estate, and they will come back within 45 days and say whether or not there is a claim. Just so you know, DHS is working and operating just the same as they were before the pandemic. As I noted, there are things called hardship waivers, which means that if the claimant, your client, was a caregiver for the decedent who was receiving medical care and living in the property for a certain period of time, they could, by nature of that, it could wipe the entire estate recovery claim off and you wouldn't have to worry about that. There's also postponement, which could push it off until the end of the client's life. here's some information on tax and mortgage foreclosure. Again, we are back to normal for the most part. Tax and sheriff sales are active again. People are able to have and use the mortgage forbearance if they choose to, as long as the national emergency exists. And as for right now, I believe it exists through April, although the Senate may decide to change that. And mortgage foreclosure diversion programs, the conferences are being scheduled, although it's a little backlogged. Know that if there's an issue like this that's occurring, it will be in the case file, and Philadelphia VIP will be aware of it. You will be primed and aware, and it would be made known in the case summary as well. So you're never going to get something that is extremely crazy like this that we haven't seen. Like we do everything we can to make sure that you are aware of this beforehand. And for a lot of you, I recognize you don't want to deal with any of these things, so don't worry. It's not going to be something that you see anytime soon. But when you're, as I've alluded to, the cost of probate is high, and there are that has been difficult for people to try and get access to funds. And so the most important way, aside from being a pro bono attorney, that we can help our clients is through the Tangled Title Fund. And the Tangled Title Fund is a grant program funded by the city. It's administered by VIP, and it's specifically for tangled title cases. There's a committee of people, and we receive applications every month. And every month we approve as many applications as we can for payment of probate filing fees, transfer taxes, inheritance tax principal. And those are really the big things that are needed to help untangle title. Probate filing fees it's the gate to open up everything. Transfer taxes is for recording the deed, and inheritance tax principal is for when we're paying the inheritance taxes. Additionally, costs can be for water and real estate tax principal. And if advertising or publication is something that's necessary, then it would pay for that. Those can be in probate cases, although the committee may give you a suggestion otherwise, or it could be for a quiet title case if the court requires it. Applying to the Tangled Title Fund is very simple. A lot of the cases that you receive have already had an application filled out, but if they haven't, the TTF has a website that is attached to ours, and we have very simple steps to show you how to do it. I also included the application in the materials. We are currently accepting electronic signatures. Although everybody who is a VIP volunteer will receive a title report if you are from another legal services organization. For now, there are applications being accepted without a full title report. Okay, so
Mike, before we move on, I just want to reiterate that for anyone who's new to this on the call, which I think many are, it may seem like a lot, it may seem like very technical stuff. We're not writing briefs to courts. We're not doing motions for summary judgment here. It's very it's simple. It's a simple process for TTF applications. It's a simple process to file a probate application. It's very simple to review a title report. It's easy to communicate the issues to the client because they aren't as manifest as broad as this program is representing. Not to say it's not correct, but no case has all of the problems that Mike has described all in one all the time. And so I just want to reiterate that this overview is a way to explain the process and the need, but the actual getting it done is not hard at all. And I'm not getting paid to say that. I'm just talking from my experience that this is this may seem like a lot, but it really isn't so bad.
Yeah, thank you, Diane. I often say that sometimes the hardest thing is getting someone to sign something, and that is just a product of COVID right now. So we a lot of the materials, the petition for probate, the TTF, are something like name, date of birth, date of death, address, and information like that. And we will have all of that information in advance, but I am always happy to review these things and help guide you through them if you have questions. So we've gotten everything prepared and we're aware of the situation, and the client has said, I'm ready to proceed with probate, and we've applied to TTF. Now we're ready to probate actually. And as I said, probate has been historically the largest obstacle in stopping the proliferation of tangled title because it's costly. So what our goal is to get the client. It could be someone else in a certain case, but likely it's going to be the client to be the personal representative of the estate. An executor is someone who was appointed through a will. An administrator is someone who is appointed through intestate law. So that would mean that in our case with Sarah, Sarah would be the administrator is our goal. Typically a surviving spouse would have priority, but otherwise intestate heirs have priority as well. And if a spouse doesn't want to serve, then they are welcome to sign what's called a renunciation. And a renunciation looks like this. And this is what Sarah would get Rita, and hopefully she would get Uncle Jack to sign, and she would also get Anthony, her brother, to sign. The renunciation is, it says that the person who is signing, so Aunt Rita, Uncle Jack, or brother Anthony, don't want to serve as the administrator, and I am nominating my sister Sarah, my niece Sarah, to be the administrator. And it's signed and notarized, and it can be done at the Register of Wills, or it can be done somewhere else. Diane, do you have any?
No. As Mike said, the hardest part sometimes is getting people to sign things. But I have to tell you, friends, I did all of this mostly through COVID, and most of my probate cases, as I think about it, really started, unfortunately, this anniversary of this day, 2020, when COVID really started raging, and I started taking these cases. We were, just getting things signed by in front of a notary. So far, probably has been one of my hardest things to do, and not hard. It's just a matter of just doing the logistics of it. And you'll be surprised. These clients are so sharp and so smart and knows, and that's what. When Mike introduced the program, he said the community, and I'm thinking, who's the community? Well, obviously it's our clients and everyone we're all living in the city together, helping each other. The clients are resourceful, and when something is needed, they want to get this done. They're not coming to do this for anything else but the end game. And so I have had, I would say, nearly 100% cooperation with clients. I've had 100% cooperation, and I've had 99.9% of kindness in the process. These folks really appreciate what we're doing and want to work with us as teams. And that's how I approach these cases. We're in this together. And so that's a long way to respond to the renunciation. I've gotten renunciations from family members because they don't want to do it. They really don't want to be involved. They love their sister, Sarah. They want her to have the house. They have no interest. It's not about giving up their interest in the house. It's about giving up the responsibility of probating their relative's estate. And it's just getting the notarization was the hardest part for me in most of these cases. That's it.
Yeah, and VIP, we have on staff notary Joe, who is a friend, but a colleague also, and also a notary. We are able to do notary appointments right now. We'll have to schedule them, but we also have a number of places that are able to do notarizations as well.
Lisa, did you want to say something? Just the mute came on. Yeah, Jenkins Law Library, free notarization. Traveling notaries, yes, they exist, and they will come. They are volunteer lawyers who are, or maybe not lawyers, whomever they are giving their time and services as you are too. As a volunteer, they volunteer. So I've had traveling notaries stand outside of people's houses and sign things with everybody wearing masks, because that's what we do.
So you've gotten the renunciations from everybody. Uncle Anthony happens to, or rather, Uncle Jack shows up. He says, "Sure, sign this thing." Aunt Rita signs it. Brother Anthony signs the renunciation. You're ready to. You have the death certificate for Grace. You're ready to proceed with e-filing probate. And what happens is you would file a petition online. I actually have another training that's all about this. I'm happy to go over it. And I'll show you what the petition looks like. Again, it's very much name, date of birth, date of death, who is going to be the petitioner or who is the petitioner. And after you've e-filed the petition, you would reach out to the Register of Wills and request a virtual or in-person oath. And I'll go over that in a second. You'll submit the documents and then you'll schedule the oath. And the oath then occurs. And that is really the, as I said, the gate to open up everything. This is the petition for probate. Note that everything below here doesn't need to be signed. This is the only thing that is signed on this page. And this is all just very simple. Who is the decedent? Is it grant of letters testamentary, which is when there's a will, or is it letters of administration? And then here are the heirs.
Mike,
Diane, yeah.
I'm just thinking, but yeah, just so you guys all know, I did this almost all online. Is that right? Correct. Fill out the petition online, and then ultimately the client has to, typically the client's the administrator, representative. They have to give their oath, whether in person or on, like through Zoom. I think that's what the Register of Wills uses.
And so as alluded to, the oath of the administration, following your e-filing, you speak with the client and say ask whether or not they want to do it virtually or in person. I have in-person information, how to schedule that. I have virtual scheduling information here. If you have questions on this, reach out to anyone at VIP. I have done this with a lot of people. I have great contacts with Lewis. I have great contact with Justin. I have contact with people at the Register of Wills. If you have questions, I am happy to assist you. This is the moment that the client becomes the administrator. And so it's very important. Just so you know, virtual oaths are taking about 1 month to schedule. I looked earlier today and it looks like May 22nd or April 22nd, excuse me, is the first available day as of now. In-person oaths are very accessible. I called this morning and I was told that I could show up tomorrow morning or Monday morning. So it's a matter of making a call and just setting the time. Things to think about is whether or not your client is mobile, whether they have the technological capacity or the urgency. Just so you know, virtual grants of letters, after you've done a virtual granting of letters, you should schedule an appointment to drop off the documents or mail them. So that would mean the letters of, the renunciations, the death certificate, if there's a will, and then the signed petition for probate. You could schedule an appointment to drop it off or mail it with USPS certified mail overnight. I will just say I do everything in person. Things have been lost before in the mail. And so if you are able to schedule an appointment for in person, it just makes life easier. After the receipt of payment and full review of all of the documents, the grant of letters will occur and they'll be issued by mail to you as the attorney.
Hey, Mike,
Right.
just if I could just add a little bit of timing. Once I get a file, very quickly, I have the conversation with the client about the risks and rewards of proceeding with probate and how to do it and what the estate is exposed to in terms of any potential creditors who might come out of the woodwork, et cetera. But I quickly make an appointment with the Register of Wills that works for the client's schedule, but also that is timed after I expect to get a check through the Tangle Title Fund. And what I mean by that is that's almost like a 30-day built-in time wait, because Tangle Title process is on a schedule. So if I have a new case in mid-December, I hopefully can maybe even make a request for Tangle Title by the first Monday of every month. So by the first Monday of January, my application for the client will have been submitted. I have to wait both for them to approve it, which is in the middle of the month of January, and then I need to receive a check cut that covers the probate fees, renunciation fees, and all that stuff. So that'll probably, I forget if that's another 2 weeks or 30 days from when they approve, our client's application. Oh, I also have to request the payment. There's a request to cut the check form, and therefore, as I said, that's like a 30-day window right there. So the expectation, the perspective on timing is as Mike started this program, timing it's tortoise more than a hare.
Yeah, and that's perfect. So I would say if you're able to schedule your grant of letters for a month from now, you can contemporaneously submit an application for TTF. Again, as Diane said, applications are due the first Monday of the month. The committee reviews it the following Tuesday, and then it takes about a week or two for the checks to be cut, and then you can either pick them up from our office or we can mail them to you. But all in all, it takes about from the first Monday, about 3 weeks for a check to be in your hand. So it's something that you should cognizantly plan just to coordinate, so you have a check in hand. If you're going in person, it just makes things easier. Final steps. So you've opened the estate. Final steps. But what happens is you will be providing notice to the heirs. Hey, we opened the estate. There's a form for that. Then you provide the inventory. There's a form for that. And it's just reiterating what we found in the estate. And that is the property. There'll be inheritance tax returns and an income tax return for if necessary, for the final year of the decedent's life. And estate taxes for millionaires. So I was having a conversation with my sister yesterday, and I was talking about, she's probating her girlfriend's grandmother's estate right now. And I was giving her it's the same exact process in New York. They just changed the names of things. But I was talking about like what the next step is. And I said inheritance taxes. And she said, we don't have inheritance taxes in New York. And I was like, that's really annoying for us in Pennsylvania. She said, but we do have estate tax. And I said, what is it, like $12.06 million? She said, no, it's like $5 million. So like, it's not really affecting us. But we don't have, no, we do have inheritance taxes in Pennsylvania, but no, we don't have, rather, yes, we do have inheritance tax in Pennsylvania, but no, we don't have estate taxes in Pennsylvania. The current federal estate tax is $12.06 million. So I feel confident that our clients will not be paying any estate taxes.
Mike, if I can add also,
Please.
Just say again, the paperwork, I can't reiterate enough that it sounds like a lot, and it is very simple. And most importantly, it's because the estate, as Mike has said, basically typically has one asset, and that is the house that the client came to say to you, I believe I can inherit and I want to make repairs. Can you help me? So all of that sounds like a lot, but it is a very simplified process. And if Mike has said this, but if I haven't, I personally, perhaps to a fault, lean on VIP, Mike and others there with incredible success, because Mike never hesitates to say, I'm here to help. And quite honestly, I feel I'm retired and solo and on my own. And so I have Mike look at the inheritance taxes, because there could be a digit out or wrong, or I just forgot something along the way. And so, but the process is simple. It looks like a lot. Mike and others at the agency are phenomenal in terms of providing support. And I mean it.
Thank you, Diane. I think it was I was in a meeting, and Kate Dugan said that like there was an inheritance tax question, and she just said, Mike Jones likes looking over inheritance taxes. Have him answer it. And it's true. I like looking over inheritance taxes. So we've gotten this paperwork, which is more simple than I've said. And then the estate is really, it's ready to be closed. We've got a few other steps, but there's a status report that needs to be filled out, which is checking boxes that the estate has been successfully probated, that you've made the distributions, and that the estate is ready to be closed. And you can schedule an appointment to drop off the final status report. Be patient. While you're doing that, while you're waiting to submit this final status report, this is the moment we can prepare and record the deed. The deed is transferring the property from the heirs to the client. There, in Sarah's case, we're going to have Uncle Jack, Aunt Rita, and Brother Anthony all sign the deed. And we have notary services available. I'm sorry, this says VIP are not currently available. That's not true. VIP notary services are available. I apologize for keeping that old language in there. But we also have deeds. We have sample deeds that are always available. They're on our resource library on our website. We have plenty of documents. And it's a matter of getting these signatures from Uncle Jack, Aunt Rita, and Brother Anthony. There's also accompanying the deed will be transfer taxes, or at least the transfer tax form. They're very standard. There is a small bit of math involved, multiplication, but know that often, especially in our cases, transfer taxes will typically amount to zero based on the relationship that the person who is receiving property from has with the person who's conveying property. So Brother Anthony is going to transfer his interest to Sarah, and Sarah is going to pay $0 of transfer tax because they are siblings. However, Aunt Rita and Uncle Jack each have a relationship as aunt and uncle. That is not a tax exempt relationship. There will be taxes due for that. And so you'll need to apply to the Tangled Title Fund for payment of those transfer taxes. As I mentioned, there is a small bit of math. It's multiplication, but I'm always happy to review these things. I always do review them because we will be submitting the deed for recording. We record all of the deeds for free, so I'm aware of what's going on beforehand, so I don't go into the Department of Records and hand them things and have things incorrect because I was silly and I didn't review. So once you have the deed signed and the transfer taxes filled out, and if there are transfer taxes due, the check from TTF, we are able to submit the deed for recording. There used to be, and many of you may know or recall this, an attorney affidavit that needed to be submitted alongside with the deed. That is not the case anymore. Department of Records does not want that. It is an unnecessary thing that needs to be notarized or filled out for that matter. So just don't even worry about that. So we've submitted this deed for recording, and we will hear back in 2 weeks that it was successfully recorded. While contemporaneously, you'll be working on the inheritance tax return. As I had mentioned, there is it's a form. It's simple, but I enjoy looking it over because there is some math involved. And TTF will help disperse for inheritance taxes. I have a lot of resources, including trainings that we've done, including a guide to assist in inheritance taxes. But these next couple slides are all about just, it's a balance. It's simple math. It's what is the value of the estate? And then what are the deductions? So what are the assets minus the deductions? And then what is the net value of the estate? And then you have a tax rate that is a multiplier based on the relationship that one has. So Sarah is a lineal descendant of the person that she's inheriting from, which is Grace. And so it's 4.5%. You would multiply the net value of the estate by 4.5%. But it's all very systematic in the inheritance tax, the REV 1500, the inheritance tax forms. So just be aware The taxable asset here is the property itself. Deductions can include, and that's the way we bring down the actual value, but deductions can be probate filing fee, funeral costs, any debts that may have existed at the date of death, like a mortgage or delinquent real estate taxes. I mentioned there are rates involved, but then you schedule an appointment to submit this inheritance tax return. The Department of Revenue will send a notice of return in 6 to 8 weeks. And you'll then can submit payment and then request waiver of interest and penalties. Diane.
Yeah, I was going to say, I mean, there's not always interest and penalties owed. So that's not a common occurrence. But if there are interest and penalties imposed, then VIP provides, again, wonderful help in helping to prepare a letter for the client saying, based on poverty and income, they cannot afford it and need a waiver. So, yeah, there's help along the way, even for the very end bit of this process for the client through VIP.
I did include a template request of waiver and interest and penalties in the materials that I sent to you all. So you can feel free to be overwhelmed looking at how much stuff I sent you also, but you can always just say, Mike, can you send me a copy of this template? I have them all if they aren't on our resource library. And after we've successfully probated the estate, transferred the title, and cleared off any of those potential liens from inheritance taxes, you've successfully untangled title. And the next step for our clients are to tell them, hey, let's draft a will. Let's do estate planning documents so that you won't have to go, or your heirs won't have to go through this process of confusion. It's the most important way. It's the number one way to prevent tangled title is by drafting a will. VIP is able to assist in opening a case and finding a volunteer attorney with drafting a will. You are more than welcome to help your client get the will, draft a will yourself. We have templates, and again, it's very simple because often we think of drafting a will and there's trusts and lots of assets everywhere and blah, blah, blah. But the thing here is that the only asset is usually going to be the property. And the hardest part I find is speaking with the client and figuring out who does he or she want, where they want to be the executor of the estate. So it's just a little bit of getting them to feel comfortable with this, with knowing that they're going to have to draft a will. But often at the end of this, they realize they don't want to put their family through the same exact process that they had to go through. And people are often very, very happy and willing to have a will drafted. You all should have wills drafted.
This is Diane. If I could just interject on this also briefly, just to say that, yes, indeed, many of the clients that I have done, for whom I've done probate, have become estate planning clients for the reason Mike described. The importance of all of this is not just to have a will so that you don't have to go through tangled title, because it's tangled sometimes with a will. It's just a matter of not being able to afford getting the property in the name of the people who should have it. The whole purpose of estate planning and probate is to meet one of those key objectives of VIP. Its mission, which is to prevent homelessness, I think is how it's described, Mike, in your VIP pitch, which is all of this is to prevent homelessness and to secure families in the property ownership to which they have a right. And just because you're poor doesn't mean you don't have the same rights. So those two really do go in hand, estate planning and probate. The objective ultimately being to secure your client's right to maintain their homes in Philadelphia, which is not getting harder to do, but it's getting messy out there in terms of what's happening in poor people's neighborhoods, and they should be able to keep their homes. So that's my pitch.
And with that, we are in fact through with this. So just so you're aware, what's next? What does this mean? This means, just so you know, this is a picture from 2017. Isn't it amazing to think of people hanging around in person without masks? That's crazy. So what happens next? What happens next is you're all here because you give a shit. You should absolutely take a case. I'm getting paid to say this, but I mean it from the bottom of my heart. I take pro bono cases myself. And so it's imperative that we have, I think we as attorneys have an ethical obligation, but we also have, I think humans should have a moral obligation. And then also sometimes you just like helping people because it feels good. Which I think is like a selfish way to be good, but that's okay. So you can take a case. We have a monthly case list that we send out. We have our website. You're welcome to peruse our website. Or you can say yes to me. I just sent you a case list that has, I think, about 9 probate cases that are available. The first page are some of the more straightforward ones. The second page have a little bit more narrative to them. But I would love it if anyone here would take a case. And so what happens once you've taken a case is we'll send you a case file. It's going to include, we'll send you conflicts, and then we will notify the client once conflicts have cleared, and we'll send you this case file with this email. We are the primary malpractice insurer for volunteers working on VIP referred cases. So that means that, if there's an issue that occurs, VIP's malpractice insurer covers you. I also, it's important that we have representation agreements signed, but if you are doing a VIP case, you are covered. As you're proceeding through the case, we'll send out status reports. It'll say it's on time schedule and says, hey, what's going on in the case? But you're all going to be moving through these so fast, and you'll be communicating with me that the status reports won't be necessary. We have resources. We have a resource library. It is constantly being updated. I am always putting on new things. I'm always adding to it. I'm amending anything that's old. We have staff support, mentors, and interpreters. As I said, all the blue from the beginning. We are here to support you. We have everybody. I am a home ownership staff attorney, but everybody at VIP is kind of a generalist in everything that we do. We have experienced mentors who are available for every area. And we have volunteer language interpreters who can assist in cases for non-English speaking clients if you don't speak the language of your client. Also, we have practice groups, practice spotlights, office space, and more. So if you're interested in having a practice group, or maybe your law firm has a practice group, which is once a month or once every 2 months, we meet and we talk about our cases. We can do it in person or via Zoom. We hold practice spotlights. We've done ones on DHS estate recovery. We've done them on inheritance taxes. We've done them on family law things. So it's very just discrete topics, but roundtable discussion on what is going on and how we can proceed with a problem that someone's facing. We offer CLE, 1 CLE for every 5 hours that you spend on closed case, up to 3 CLE. Please just utilize that. Lastly,
Mike,
Diane, yes.
Up to 3 CLE per reporting period, I think.
Up to 3 CLE per reporting period. There you go. I never know when it ends. But thank you. And then upcoming events. As I had said, we have the 40th anniversary on May 7th. I really hope that you are all going to be there. I'm going to dance my socks off. Next week, we have a Welcome to Philadelphia VIP event. It's just an introduction of what VIP is. April 13th, we have the Family Law Practice Group. It's going to be on Zoom. And what I've decided to start doing the 4th Friday of each month from 10 a.m. to 1 p.m. It's going to be called Home Ownership Office Hours. You drop in and ask your questions, just chat with someone from VIP. It's me. I'm the person that you will most likely be chatting with at VIP, but it is an open space for you to drop in at any point and ask questions or have a conversation. It is not formal. There's no registration that's needed. We have the link already up on the on our webpage. So I will, fourth Friday of every month, I will be here for you. I mean, I'm always here for you, but if you want to have a conversation, that's a great time to have it. Otherwise, that's everything from me. And I'm going to say thank you to Diane. Like an immense thank you to Diane for helping with this and for everything that you do. Like you're the bee's knees. I think that you are amazing.
I think the Jameson's kicking
in. But I'm extremely grateful for everyone who's here right now, who's shown their support to an interest in being a VIP volunteer. And I'm also now, I'm going to turn the video off. So thank you to everyone for being here. But I'm going to